I'm John Quinn, the founding and managing partner of Quinn Emanuel Urquhart & Sullivan. Welcome to my new podcast, Law Disrupted. In each episode, I'm joined by industry professionals to debate and examine the legal matters surrounding emerging subjects such as SPACs, NFTs, litigation finance, ransomware, autonomous vehicles, crypto, and many more. Sign up to receive an email when a new episode drops on our website, lawdisrupted.fm. So don't forget to like, share, and subscribe. This is John Quinn, and this is Law Disrupted. And today we're talking with Dan Rabinowitz, who has a business, Pre-Dicta, which is really fascinating. I think it'll be fascinating to all litigators. I mean, every litigator, when you have something going before a court, a motion, you're trying a case, you're going to a court's going to make a decision. You're always thinking about, of course, what might motivate that court? How is the court likely to rule? What things might make a difference to that particular judge? And Dan's business puts some science around that, helps predict how judges are likely to rule. And is that a fair summary, or correct me if I've got that wrong, Dan?
No, that's a very good summary.
So tell us about this business. It sounds so fascinating.
Sure. I remember when I was a young associate and we were practicing, and we had a products liability case in front of a judge. The judge was in Alabama, and we had a motion to dismiss pending. And my task was to go ahead and collect all the cases or all the decisions the judge had for a motion to dismiss and try to determine, whether the party that we represented, like what effect that would have on the judge. What impact would it have? We had, all of us had sat down, we had written a great brief, we had great arguments. But the question is what is the judge going to do, and whether or not we can divine any information about that from past decisions. Now, as you would imagine, there were only a handful of decisions, none of which were actually relevant in the sense that they didn't address the specifics of our case, which was we had a very large pharmaceutical client, and this was a products case, and it was an individual on the other side. We didn't know whether the judge would be sympathetic to any of that, or whether or not the judge would be more skeptical of our firm, which was, a large international firm. This was in Alabama. How would the judge view that? And then, sometimes people go ahead to their past experience in front of any given judge and try to, make predictions based on that. But the limitation of that, of course, is judges hear, dozens of cases potentially a day. And even if you have, if you will, a consistent track record in front of a judge, I think even a litigator that's practiced over 20 years, it's 25, 30 appearances before the judge. And then you think that the judge actually had, 4,000 cases or motions in front of them, or 10,000. So it's really hard to use that small data set to extrapolate what the judge and how the judge is going to perceive the specifics of your case. So a bunch of years ago, I had an idea that perhaps one approach is to step aside from the law and the facts, and instead look at the person. Look at the personality, look at who the judge is. Because we all understand that the way that human beings are programmed, there are different life experiences that we have, different different perspectives that we have on a variety of different aspects of life. And in order to determine how those might influence us, you really have to know us as a person. And so what we decided to do was to take two different pieces of data that we had available. The first is to go ahead and take a look at what the judge has done in the past. But of course, as I mentioned, the limitation is that their opinions don't really provide a lot of insight into how they're going to react to the particulars. And also the severe limitation of the opinions is that when it comes to motions, judges write opinions in around 2% of all motions that they hear. So 98%, there is no evidence, there is no record.
There'll just be a docket entry granted or denied, basically.
Exactly. And there are some, that try to extrapolate from that. But of course, even basics, a basic knowledge of statistics tells you that, past history is not really indicative of how the judge is going to rule here. 75% in the past doesn't mean you actually have a 75% chance. And the reason for that is because we don't know all the variables that put you into 25 or put you in the 75. So we went ahead and looked at all those decisions, but we decided the way to look at those was to try to classify, categorize, and understand the parties and the attorneys that were involved in those decisions. So once we did that, we then took that human piece of it and we looked at who the judge is. We started modeling who the judge is, politics, gender, net worth, work experience, educational experience, geography, and around a couple dozen others.
So how many total data sets would you be able to pull together typically on an average on a judge?
So in terms of the total data sets, in other words, picking particular data sets, we probably looked at, ultimately, I would say it's 6 large data sets that relate to judges.
Mm-hmm.
And from those, we called, because not all that is necessarily relevant or even tangentially applicable. But then ultimately that created a model where those characteristics were included. And we have around, as I said, it's probably 6 or 7 dozen different characteristics. Some of them matter in some instances, some of them don't matter. But that's all part of the analytics.
So these would be, for example, gender, locality, political affiliation, ethnicity, things like that.
Yeah, education, work experience, were they in private practice, were they, in public service, where they went to undergrad, where they were born, where they live.
Right.
All of that comes together because if you think about how Google is so successful in placing those ads that we almost assume that they're listening in on our conversations,
right.
It's because they have all that information. They know where we live.
Mm-hmm.
They know our income, they know who our friends are, they know where we went to school and so on. And that's how you're able to create highly accurate predictions.
Right.
And then the question is, though, how you then understand the judge with regard to the characteristics of the case. So that's where those historic decisions and the classifications and categorizations come in. And then from there, because all the work is done on the back end, that is in creating those models and creating both the judicial models and analyzing and processing the data in order to see patterns and trends that are otherwise invisible to attorneys, our software is incredibly straightforward. We only require the case number. And to be clear, not only do you not have to upload your briefs or any other information for us, when you do that, we don't look at your briefs when we're analyzing a motion. Instead, it's those other factors that ultimately will determine how the judge will rule. And through our algorithmic models and through the AI that we use, based on our backtesting, with just the case number, we are correct 85% of the time.
That's amazing. That is astounding. You know nothing about the substance of the case. You know nothing about, I assume that one of the factors is what's the nature of the motion. Is this a motion for summary judgment? That would be one factor that you would include in your model.
So currently we focus on motions for dismiss right now. We have other capabilities as it relates to summary judgment, but in terms of the actual predictive capabilities, right now where the technology is at the motion to dismiss. But certainly the motion to dismiss, one factor that we consider is the nature of suit. Mm-hmm. But even that is somewhat amorphous because, number one, you can only enter one nature of suit in the federal system and even in most state systems. So that's number one. And number two, there's no one that's actually checking the accuracy of that nature of suit. So that's certainly one component that is, if you will, gets to the facts of the law. But then all the rest that we're looking at are those other unique characteristics, those other influencers that are involved in the case.
You also look at the characteristics of the litigants, the parties, and the lawyers, in addition to all the things you described about the judge.
Yes, exactly. We are trying to match those, again, to see the patterns and trends in the judge's past decisions, right? How they dealt with that individual, how they dealt with a particular lawyer type or particular lawyer or firm type. And the combination, of all those together, and that is specific to the case at hand, and then how that's influenced that judge in the past.
I guess the idea that you could predict how judges could rule on a motion to dismiss may, to some degree, would not be surprising to a lot of litigators because judges get reputations about, what's their belief in jury trials, how aggressively do they manage their docket, how plaintiff oriented are they? Do they believe liberal? They have sort of liberal ideas when it comes to pleadings. I mean, that strikes me as one motion that is particularly susceptible to this type of analysis.
Well, it is and isn't, because if you simply look at, for example, liberal or conservative, there's only one factor that ultimately forms us as human beings, and highly reductive. And then if you start overlaying other aspects, obvious aspects of humans, so if you have a liberal that, for example, went to a conservative college or a conservative law school, how does, they went to, and these are broad generalities, University of Chicago versus, Berkeley, but they're a Republican. And maybe they live in a particular neighborhood that you wouldn't necessarily associate with conservative values. And how do they truthfully deal with, individuals? Are they totally sympathetic to individuals? I mean, one of the analyses that we actually did, sort of as a secondary analysis, frankly, almost driven by my own curiosity, was what is the effect of presidential appointment on judges, specifically as it relates to a motion to dismiss, and whether or not we can detect corporate favoritism. And we detect that particular judges, based on who appointed them, are more favorable towards corporations. And the results were, in some ways, highly surprising. And then sort of when you try to walk it back, a little bit less so. So as it comes out, female Democrats are about as sympathetic to corporate parties as Republicans overall.
Really?
Yes. The worst, if you will, the least favorable towards corporations are females appointed by President Trump.
Okay.
By almost 10 percentage points. Now, how would you have...
That's like counterintuitive.
Counterintuitive in some ways, although if you sort of try to roll that back a bit and you think about how, and this is not this is not to get into politics. I think everyone would agree that President Trump is a different type of Republican that preceded him. And his judicial appointees, many of them were, let's just say that they didn't take the same mold as other judicial nominees, whether it be Republicans or Democrats. So the fact that they are, if you will, outliers, or that they fall to one extreme or the other, isn't necessarily all that surprising once you start thinking about that, where they went to law school, right? What associations all those judges were affiliated, and when you start breaking it down that way, you can see how that totally counterintuitively, right? You would arrive at an entirely different assumption that in fact is not the case at all. So that's really the limitation that attorneys have, that they have such a limited lens into who the judge is. Yeah, maybe they know which judge appointed them, which president appointed them. Mm-hmm. But are they really liberal when it comes to a contract matter between two large corporations? I mean, does it matter to a judge that went to Harvard that the lawyers that are appearing before them also went to Harvard? Does it matter in the sense that they're more skeptical of their former colleagues, or are they more willing to accept what they say and give it more credence? And when you start sort of playing this out and you realize no one element can you really use if you want to get an accurate prediction that you can go to your client with, right, and say, I know how this is going to come out.
Mm-hmm. Well, I mean, this raises the question, this based on this capability, are there things that a litigant, a lawyer, a party can do to improve their chances of success? I mean, you typically can't change the judge. The judge, at least in federal court, you're assigned to a judge, and that judge is going to hear the matter for all purposes. I suppose you can change your lawyer. If your analysis shows that, if your lawyer went to a small state school, you would have a material better chance of success with this particular judge than the present graduate of Harvard who's representing you. I suppose that's something that you could do.
Sure, but actually, when it comes to even federal judges, we had a client that was in front of a judge in the Southern District of Florida, a large, fairly decent-sized case. And we went ahead and ran our analysis on her to determine whether or not they would rule in their favor. They were on the defense side. And our analysis said, no, it's not going to happen. It's going to go to discovery and then presumably some multi-million-dollar settlement aside from the discovery costs. But they had the opportunity to transfer venue to the Central District of California. Now, of course, before a case is assigned, you don't know which judge in the Central District that you're going to get, and we're very judge-focused. So the way that we deal, if you will, with the lack of determination as to the judge is we run our analysis on every single judge in the Central District of California. We provide an overall score, and then we also understand what each of those judges will do. And you could also, if you will, filter out for senior status judges because they're less likely to take the case. And when you do that, you see you have a much higher percentage of success of the motion to be granted and the case to go away. So you're essentially taking, millions of dollars and you're reducing it to zero simply by using the AI to your advantage.
Right.
Now, of course, it ultimately may be assigned to a different judge, but just think of that, like on the one hand, with almost 85% degree of certainty that this is going to go to discovery. And if you had even a chance that wouldn't happen, and a good chance, of course you would avail yourself to that. I would think.
I would think so. This is fascinating. Are there things that you're working on being able to apply this technology to other types of decisions other than decisions on motions to dismiss?
Yeah. So first of all, we began when we launched. We had complete federal coverage of civil cases, motions to dismiss. I can't tell you about the recent indictment and how that's going to go. So we have coverage of pretty much all civil cases at federal court. We acquired the assets of a company at the beginning of the year that had large amounts of state data. So we're in the process of applying our approach and our models to state court data. So we'll be able to provide those same predictions at the state court level for motions to dismiss. We're also working on summary judgment and trying to determine what we can do and what approach we might do apply there. Additionally, as you mentioned, as it relates to attorneys, we're almost finished building a module mainly for in-house counsel that would enable them, as most large corporations have panel counsel, for us to assess, at least at the motion to dismiss stage, whether or not picking a particular counsel may have an impact on the motion to dismiss. So exactly the scenario that you suggested is what we're rolling out in the near future.
Yeah, I would think, judges certainly have reputations for their willingness to grant summary judgment motions. So assuming that there's something to that, the judges act consistently and that they're, and your data assumes that judges will sort of act consistently. That seems to be an obvious potential application for this software.
Yes, it absolutely is. But again, I want to distinguish between what the reputation is and then what the data actually bears out, right?
Right.
Of course, those can be two very different things.
Sure. That's anecdotal. Yep. Lawyers think they have a read on that, but you've got some actual data that will indicate whether that's true or not.
Yeah, we had a fascinating discussion with a potential client that was a large plaintiffs firm, very large plaintiffs firm. And in order to test our models, if you will, they sent us 25 of their most recent cases. Now, of course, 25 technically is probably too small of a data set, but you have a potential client who do what they ask.
Right.
And they had provided us with the names of the cases and the judges and the numbers, but they also gave us a column with the outcome, which I was kind of surprised, but whatever, I could figure it out anyways on my own. And it was 25. And when I ran our analysis, we correctly anticipated 20 out of 25. When I sent it to him, he actually said, our 20 is incorrect because one of the cases he said was quote unquote miscoded. And really it's 21 out of 25. I can't say if that was deliberate or not, but be that as it may, 11 out of 25 were dismissed. And this is from plaintiff's side, right?
Right.
So for those 11 out of 25, it was a total loss for them.
Yeah.
Total loss. And these were big cases. And nearly half, we talk about like anecdotal evidence, right? So nearly half of the cases that they thought were going to be winners are losers.
Mm-hmm.
Now, that to me, every one of the 11, by the way, we correctly predicted would be dismissed. Now, with that information, knowing that it might be dismissed, knowing that we can do a jurisdictional analysis even before a case is filed, you could take those 11 losses based on presumably what these lawyers thought would be, good jurisdictions, good judges, because they always appear before them, and turn those into wins. And, one of the issues with law generally, I would argue, is that it's fairly conservative, meaning, and that manifests itself in a variety of ways, one of which is on the plaintiff side, for example, they always file in the same district. Once they determine that a district is favorable, then they just go there. And same thing on the defense side, that this district is better for our corporate clients.
Right.
Now, that may or may not be true, but it might also be true that there are 20 others that are equally good, if not better.
Mm.
But because you're conservative and you just stick with what you know, and you don't run an analysis, because of course it's too difficult for any given lawyer to do that. It requires crunching, dozens of years of data, looking at, eventually hundreds of judges, looking at thousands or tens of thousands or hundreds of thousands of decisions. So they basically just go with what they know without knowing whether or not that is actually the best approach.
Mm-hmm. So, where you have options about the different jurisdictions and venues in which to file, this gives you an ability to make an intelligent, evidence-based decision about where to file. And sometimes, making motions to dismiss can be expensive. And a lot of times you wonder, is it worth it? Is it worth investing in this? There's a cost, not only in attorney's fees, but you give up an element of surprise. You lay out your arguments, you educate the other side. So there's a cost in that sense too. So I can see that being able to decide, and there's a low probability of success. We'll save the money and we want to educate the other side. And having some confidence in making that decision can be really valuable.
Yes, exactly. And that doesn't have to do with the strength of your case. It simply has to do with the judge that you were assigned to.
Right. So do you see a time where you'll actually read the briefs instead of just get the docket number, but, be able to code for arguments, if you will, and help lawyers make decisions about what arguments to make to a particular judge? Is that down the road?
No, because we, again, view the decision maker as the most important component of any given case in terms of prediction. Lawyers have a pretty good sense of arguments and strengths and weaknesses, and this is not intended to displace that. One of the things that you constantly hear with any new technology, how many people is this going to displace? Or are we all going to lose our jobs? And I think, frankly, that's kind of a juvenile approach. And if you look at the history of technology, that certainly has not been the case generally. Instead, what it enables us to do is to be more efficient or to be smarter, right? To use the technology to our advantage, to crack open a black box that we otherwise were unable to get to, in this instance, the judge. In terms of the arguments, in terms of the case law, the variety of the commercially available databases, entry, like which cases the judge cites more frequently, not that necessarily tells you about weight or applicability, but I'm sure the AI will get better, that it might be able to identify more compelling arguments. But in terms of our capability, what we found getting to 85% is that the briefs don't have or don't enable us to arrive at any better prediction. To the extent that the 15% is there, based on our analysis, a lot of that just has to do with a lack of information at this point in time. Meaning, like the judge, all things being equal, would in fact rule in favor of your motion, but for whatever reason, they got in a fight with their spouse on the way out the door, their partner, and therefore it just throws off the way that they act that day. And look, 15% is something, but it's a very, very small amount when you think about it. So there are some variables, potentially, maybe we could close that small 15% gap with some analysis of the briefs. But when we were looking at, when we were building our models, I mentioned the limitations of natures of suit. One of the analysis that we did do was through complaints and trying to determine which natures of suit better, conformed or were more expressive of what was actually in the complaint. So we certainly did look at documents. But in terms of the briefs and the arguments, that we sort of leave that to the attorneys to continue slaving at and billing by the hour.
Well, you can imagine, some recurring issues. I'm struggling to think of one, say federal preemption or, some judges seem to be, have a greater proclivity to invalidate patents or trademarks than other judges. Or, you can imagine legal issues that are recurring all the time. And couldn't you collect data points on how judges rule on these recurring issues?
So the way that we look at that is it's not recurring in the same sense that you are using that word. It's not recurring simply because it's a patent and they're more skeptical of patent or trademark claims. It's recurrent because it could be the party types are the same. It could be that the lawyers are the same people that are appearing for them over and over again. That's what's recurrent about.
Uh-huh.
So if you want to look at the capability to find that pattern, that recurrent pattern that you could point your finger at and say, if these criteria are here, we know how the judge will be necessarily skeptical, or the judge is going to invalidate the patent. But it's finding those recurrencies, if you will, that is the key. And the recurrency is not simply the subject matter.
Hmm. Well, you mentioned that at one point you worked in a large international law firm. How did your career evolve to the point that, you were an associate, and I don't know, maybe a partner too, in a big international firm, and now developed this AI capability to predict what judges are going to do?
Yeah, so I'm based just in DC, and I like to think I have a fairly traditional DC career trajectory up to a point. Started at a large firm. I went to school in the DC area. I started at a large firm, went to the Department of Justice to do litigation, went in-house at a defense government contractor. I think all that is real boring chatter at a cocktail party, certainly in the DC area. And then ultimately, I ended up at a small data analytics company that had access to a number of analytic platforms that were mainly being used in the intelligence space for a variety of intelligence agencies. And it was there where I started to understand the way that we look at things in, if you will, the real world is very different than in the way that you want to run an analysis. In that instance, where the next terrorist attack may come from, or who's a threat or who's not a threat. And a lot of that has to do with the approach to data, understanding that we are, if you will, one person, but we have a lot of component parts, right? So if you think about the way that we break down the judge, and their component parts, and perhaps when you're thinking about those, actors, and again, in the intelligence space, you want to find commonality between them, but it's not simply going to be their name. It's not simply going to be where they live. It's these other characteristics that you have to sort of understand and use a massive data set in order to find those patterns and trends. So that's where I had the idea potentially that we might be able to harness big data and then specifically focus more on the individual, that is the judge, rather than the legal aspects of the case.
Well, it's fascinating. How do you see this? We've talked a little bit about the potential applications for summary judgment. Do you see any other applications for this approach to using data analytics to predict decisions made by judges? What's in the future?
So I think that that this approach of looking at the decision maker is very important, and that can be applied in any number of at least legal contexts. It might be you're looking at, for example, antitrust or something else, whether or not the government will approve or deny or decide to intervene. If you understand who the actors are in that decision and you have enough information, that's a potential use. Of course, any motion that's involved in litigation. But then there are other ways of looking at predictive technology and sort of expanding its use. So if we're capable of using predictive technology, of course, we're able to look beyond the law and beyond counseling one's clients. So if you want to understand, let's say, publicly traded companies, impact of litigation events, of course, knowing the outcomes is very important and can provide an advantage. In terms of litigation funders, really being able to do an objective assessment of the case beyond the merits. You're anyways building financial and economic models. So that certainly is a distinct application. But then in terms of just how you deploy it, it's really taking the central premise that the actors matter more, and what matters to the actors is not necessarily the substance. It's these, if you will, seemingly external elements in any decision making.
Well, this is really fascinating stuff, Dan. How can people find you if they're interested in following up? Your name, your business is Pre-Dicta, PRE/Dicta, DICTA?
Correct. PRE/DICTA. We have a website. More than happy to reach out to us. I would just mention, just because you brought up like how it can be used, just sort of to emphasize the power. One of the questions I get asked is, what do you do with newly appointed judges? Right? I've talked about judges and how much we know about judges. What do you do with newly appointed judges? And this is where the biographical characteristics really come into play. Because with a newly appointed judge, while we don't have their decisional history, we do have their biographical information, and we can then match those to judges that have been on the bench for years or decades. And we use those judges as proxies for what this newly appointed judge will do. And admittedly, we aren't quite as accurate. From 85, we dropped to 81. But the reason that it's such a minimal drop is because the biographical, matching those non-obvious patterns is so important in determining the decisions. Or put another way, a newly appointed judge, we can tell you today what they're going to do for the next 10 or 15 years of their career, simply by applying tenets of big data, AI, and so on. So I just think, back to your question about how this can be used, I really think that it's incredibly powerful. And there's, I would say, almost a nearly unlimited approach. It really just depends on how creative the person doing it. But certainly, to come back to your question, how they can find me, the internet is wonderful. Firm believer in Google and its approach. You may start getting targeted ads from us. I can't say one way or another.
Okay. Well, thank you, Dan. We've been talking to Dan Rabinowitz of Pre-Dicta, who has a fascinating predictive software capability to predict to 85% accuracy how federal judges are going to rule on motions to dismiss and a lot of other potential future applications. This is John Quinn, and this has been Law Disrupted.